clearly shows me what the board was considered, that what was considered at the time, I should say the board, was considered at the time was a move from 1 to 2 rather than 1 to 3 units. In terms of the arguments made by the appellant, really what they tend to show is that arguably that the owners were planning to use it for 3 units, which has nothing to do with whether they were permitted to use it for 3 units. It doesn't really show that, any agency of the town was considering it as a 3 unit, but even if it did, even if there were people that through conversations or otherwise working on the, working for the town and the various groups that had to approve it, contemplated it was going to be for 3 units. I just don't think that's of any legal consequence. I don't think there's a doctrine here akin to adverse possession where something has been treated a certain way for a long time that it acquires the rights to be treated that way. Certainly no such case law was presented to us. So, given all that, I would deny the appeal.
I'm sorry, could you repeat that? You would not what?
I would deny the appeal. Affirm Jody's decision.
Okay.
Yeah, to me it was telling that the plans did not show a kitchen on that 3rd floor. So to me it was not originally intended to be 3 families. It was originally intended to be 2 families. So I would affirm Jody, yeah.
And for the record, that was Art.
Yes, I'm sorry. Yes.
Frank
Barada, yes. I want to affirm Jody's decision. Yes.
So my thought is it's probably a classic case of somebody doing something without necessarily getting the proper permits, which doesn't change Jody's ruling whatsoever. I mean, it seems fairly likely that they intended to, since they did 3 boilers and 3 electrical panels in, but the drawings that Jody showed very clearly don't show a unit up on the 3rd floor. So I would also agree. So ruling on Jody's first, since we need to take that separately. Do we have a motion?
It's Ken Rogozinski. I'd make the motion that we deny the applicant's appeal to reverse the zoning enforcement officer's decision.
This is Joe. I would second that.
Motion is made and seconded. Okay, I need to do roll call. Joe?
Yes.
And Ken?
Yes on the motion.
Art?
I agree, yes.
Frank?
Yes.
And I agree, I vote yes as well. So Jody's decision is upheld. Now moving on to the second part of it, the discussion on, who'd like to start the discussion on the variance of allowable units?
It's Ken Rogozinski. I'll say that I've got a problem with that. I mean, I understand the fact that it's been operated this way for 35 years and that the owner self-reported themselves in terms of not being in compliance. But to me, that doesn't then demonstrate a hardship as to why this should be done and why after the fact, once this has been brought to, the town's attention, we should just say, okay, we'll give you a variance for it. I mean, the other case like this that we heard recently, I believe was on Hamilton Avenue, where it was the same thing that the previous owner had operated it as a 3-family. They sold it to somebody else. And then John Vecchiola, I know you're not sitting on this. I believe the appropriate legal term of art is dropped a dime on the new owner to say that they were illegally operating it as a 3-family household. In that circumstance, again, you've got something that the latest plans that we have show was never intended to be this way, and without some extraordinary effort by the applicant in terms of restricting a unit to affordability or doing something like this, I have a real hard time just giving them a free pass and allowing the property to be operated on that basis.
No.
What do you think, playing devil's advocate for a minute though? We do like having affordable units, even if they're not deeded as such, clearly, and we know that one of the solutions in the long run is to make some of these illegal extra apartments potentially legal. That's something we're looking at. What do you, I mean, do you have anything, does that play into your decision at all, or your thoughts?
Well, if it's Ken Rogozinski again. If that's the case, then, from my perspective, I believe if we deny this application, then, the applicant is going to then have to think hard about coming back to the town again and saying, okay, I will agree to the deed restriction on the unit in return for having the ability to continue to operate it. I mean, I don't think that, as Tom Hegney mentioned this evening, his client currently has no interest in that solution. So I don't see what we get by granting this, because we've now brought them into compliance and they can do whatever they want to do. They can renovate and jack up the rents and have no issues with that, because we've now given them the authority to operate this building as a 3-family residence going forward. So I see no compelling hardship, and I see no compelling benefit to the community of granting a variance on this front.
And what if they were willing to, or what if we said, well, it stays the same, there is no additions, any, as I said, I wouldn't want it torn down and 3 fancy ones put in its place. And that's what I fear starts to happen in town. So at some point.
Pat, it's Ken Rogozinski. I just don't feel like I can't make those kinds of decisions in fear of what someone might do here that they're legally allowed to do as of right. I mean, someone could do whatever they want to do as of right. What I do have a problem with is just giving them a pass on this and, for all intents, getting nothing in return from the applicant for, allowing a use that really isn't allowed, and I don't see a hardship demonstrated.
This is Frank Marotta. Ken, what would you consider, or what would you want in return?
That's what, from my perspective, again, this is all a moot point, because the applicant's counsel has stated that this is not of interest to the applicant. But a deed restriction on the unit. I know the town has done that in the past with illegal units that they've allowed them to be converted to legal use with deed restrictions on them for affordability. That I don't think I would have an issue with. But since the applicant's counsel has noted that the applicant is not interested in taking that approach here, I feel like I have no alternative but to vote against the application.
But this is Frank Marotta again. But if you put a restriction on it, aren't we limiting that, or getting the same effect without the deed restriction?
The only thing you can enforce, Frank, is the deed restriction. It may be renting for $1,100 a unit now, but without a deed restriction, that doesn't prevent things from changing in the future. So, the only way that I see, any bit of community benefit to this, approval is by, getting some sort of deed restriction that goes along with that. And that has not been offered by the applicant.
Well, it seems that if we put the restriction that if they change the use, then it will revert back to a 2-family house. I think that should be adequate. Am I missing something?
It's Ken Rogozinski. Personally, I don't agree with that. I think that, to my knowledge, that's the approach that the town and the commission has taken in the past with other illegal apartments, is the approval of them, as with deed restrictions as a way to rectify the illegality. And that was not offered by the applicant here. That question was asked during the presentation, and the applicant's attorney stated that there was no desire on the applicant's part to do that or to satisfy that kind of requirement. So, from my perspective, without that, I don't see the hardship. I don't see the reason why we grant the variance.
And so let me just throw something before you, and then Art, you're next. Sorry. So, what if I guess it doesn't make sense because, or your thought is because he said no to the question of deeding it, you wouldn't want to say, we'll give you the variance with the condition that it's deeded. Because that's really not on the table. Is that what you're thinking? Legally, it's not on the table?
It's Ken Rogozinski. That, from my perspective, Pat, I mean, that I don't see the point of granting a variance with a condition that the applicant has said they have no desire to meet. So,
Right.
you know, they get, from my perspective, you get the result, which is if we vote to deny the application, we deny it. I think we're on the record now, at least I am, about stating my reason for not voting in favor of this application. And if they decide that they want this badly enough, then they can think about whether or not they follow the same road that other property owners in town with illegal apartments have done to rectify that in the past.
Thank you. Art?
I think I accidentally raised my hand, but having said that, I like Ken's reasoning. I'll stop there.
We lose.
Okay, Joe?
Yeah, I think Ken's reasoning persuades me.
Okay. I'll agree. Ken, would you like to make a motion?
Sure, I would then make a motion to deny the second part of the application for the variance.
This is Joe, seconded.
Motion is made and seconded. I'll now do roll call. I'll start with you, Joe.
Yes. On the motion.
Yes to deny the
Yes to
variance.
deny.
Okay. Ken?
Yes to deny.
Art?
Yes for deny.
Frank?
No to deny.
Are you voting against the denial? Is that what you're
Yes.
saying?
Yes, I'm voting no.
Okay. Say that again.
I'm voting no.
You're voting no. Okay, and I'm voting yes. I'll actually agree with them. All right, so that fails to pass.
Well, Pat, the motion actually did pass. Motion passed 4-1.
Yes.
To deny.
There were 4 votes to
Right.
deny.
The variance is denied, yes.
Correct.
The motion passed. Thank you. Yep. Okay. And now going to number 4, Bush Avenue.